Today I want to talk about some estate planning basics. Let's start with a will. I recommend that everyone has one. It's interesting to, if you look at history, some very famous people that have died without a will. Prince. Now, there's a trust company that's overseeing all of his music that's in his vault to try to release it, make money, and his relatives are fighting over that, and it's an absolute mess. But another good example of somebody who died without a will is Abraham Lincoln. Ran across that fact and it absolutely blew my mind, because obviously Abraham Lincoln's an incredible president, maybe our finest, and an attorney. He was a corporate attorney for the railroads and so on, and obviously a genius, and yet he had no will. And that got pretty ugly, as I understand it, because he had, I think, 2 children and his wife, and it took a couple years for everything to settle, and God knows what happened with that. But it was very shocking to see that. Nevertheless, so I think having a basic will is very important. But the thing that I point out, because you want your wishes to be executed, but beyond that, a really important part of this estate planning process is trying to avoid probate. Now, anything that passes through a will passes through probate. That would not include your IRAs. Anything that has a beneficiary on it would not include your insurance products. Anything that's got a beneficiary named on it doesn't pass through probate. But if you have a large investment portfolio, bank account, your home, collectibles, real estate, et cetera, and that is going to pass through probate unless you take some steps. So we work with partners. Obviously, we don't prepare documents on a legal basis. It's not part of our service. And one of the things that we often recommend and advise people on is to look at a living trust. Now, a living trust is a revocable trust. In other words, you can change the components of that trust while you're alive all you want, take assets in and out of it, make changes to it. It's not set in stone, as opposed to a irrevocable trust, which is kind of set in stone. It's a lot more complicated, and we're not going to get into that on this particular video. But a living trust is basically a title, and that title helps to provide someone from avoiding probate. So let's say that you go out there and create a living trust, and you retitle basically the assets that you want into that trust. And we recommend that you do pretty much the gamut. You put in your taxable accounts, your bank accounts, your home, so you have to get your deed and get retitled. And any other assets that your attorney would recommend that you do that with. And this avoids a few things. Number one, the cost. Probate costs can be huge. It's different on every state. Each state has their own scale. In California, it's graduated. I think it starts at 4%, then goes down to 2%. And I think by the time you get over a $25 million estate, then it may be 0.5% or negotiated by the state. But if you bake it all in and you look at Florida, Kentucky, where I'm from, I mean, it can easily be 3%, 4%, 5%. If you have I would say a couple $1 million or $5 million or $10 million, 1 or 2% at a minimum, and that's just anything that goes through probate. And it also doesn't include the net. So let's say that you have a $1 million house. In California, that's, I don't know what the average cost is, but it's probably close. And let's say that you have a $500,000 mortgage. Well, the probate goes on the total value of the house, and that's fair market value, I believe. So you're getting maybe a 2% fee or $20,000 on just to probate your house. It's huge. It's a big cost, and it can be avoided for the most part with a living trust. How much is a living trust? Well, you'll have to talk to the attorney, but they're not that expensive. They certainly aren't. If you look at the pros and cons of it, they're certainly worth it depending on how large your estate is going to be. The other part about the living trust that I like is that it keeps your assets private. Anything that goes to probate is public record, and so if you value your privacy or your relatives' privacy and your heirs' privacy, that's another thing to think about. But lastly, and probably I would put the second importance next to the cost, is time and trouble. So if you want to hear a horror story, I would encourage you to Google John Wayne and his estate. John Wayne died in, I think, 1979, had 7 children, I think 3 wives. Regardless, he had a will, but no trust. And they fought over that thing for, I think it was two decades. And the probate costs were absolutely astronomical. I want to say that his net worth at the time of his death in 1979 was around $12 million or $13 million. And just hundreds of thousands of dollars, if not millions, in probate and other fees that could have likely been avoided. And it drug on for years and years. So could that happen to you? I know you may not have John Wayne's estate, but or have 7 children or 3 or 4 wives, but it can save a lot of trouble potentially between your heirs. What my understanding is that it's very difficult to contest a trust. They can contest a will. And so there is kind of the linchpin that kind of helps that become a very smooth transition to process the estate. So if you do it through a will and it goes through probate, I think the average is 9 months, but it could go on if it's contested, as you've seen with the John Wayne example, for years and years and years. But if you do it through a living trust, I think that your average could be 30, 60 days, and boom, you've got everything processed. It's been clean. You've avoided the probate, and life is as good as it can be, having lost a loved one. A few thoughts there. I hope that's helpful. If you have questions on that, please reach out, message me. Please like and subscribe, and we'll see you next time. Thanks for watching.